Welcome to the Life Insurance Policy Crisis, the Advisor's and Trustee's Guide to Managing Risks and Avoiding a Client Crisis, co-sponsored by the ABA Center for Professional Development. Moderating the program today is Jennifer Kona. Jennifer is a partner with Genser, Dubal, Genser & Kona, LLP in Melville, New York. Jennifer, welcome to the program.
Thank you so much. Joining me on the program today, Robert Barnett. Also with us is Henry Montag, who is an independent certified financial planner and a principal of the TOLI Center East, which provides performance evaluation for private trustees, advisors, and institutional trustees regarding the protection of private or trust-owned life insurance. Henry is a local and national media source and is the co-author of the book, The Life Insurance Policy Crisis. Robert Barnett is a partner with Capel, Barnett, Madelon, and Schoenfeld. Robert's an attorney, a CPA, and has a master's in taxation. His practice concentrates in taxation, trusts and estates, charitable planning, corporate, and partnership law. I've practiced elder law for the past 20 years. In this ever-changing field, the one constant has been the quote-unquote set it and forget it attitude when it comes to life insurance, which leads us to this very issue we are discussing today, the life insurance policy crisis. So Henry, before you take over, what was your prime intention in writing the Advisor's and Trustee's Guide to Managing Risk?
Thank you, Jennifer. Well, look, as Randy mentioned, the current state of affairs in the insurance industry is problematic to say the least. That's for clients, for beneficiaries, for the amateur trustees, as well as for the advisors. The problem is that, as we found out in the questions, very few of either of the individuals that I just mentioned are even remotely aware that life insurance coverage is expiring much sooner than expected. And that's because, as Randy mentioned, the interest rates and the neglect, and as we'll find out in a few moments, some of the selective actions and inactions of the insurance industry. So it was my intent to reach the advisor community through the book, through the book reviews, through webinars such as this. Today I'll be discussing specific case study examples of problems, solutions, and how the advisor can better guide their clients to avoid problems in the future. My objective today is twofold. It's to be able to have all the attendees leave with at least one or two usable ideas that will be beneficial for your clients and to your practice. So there are three types of insurance policies. Up until the 1980s, it was like going to Carvel's ice cream. There were two flavors. Chocolate was whole life, and vanilla was term, and they were both guaranteed. Then in the early 80s, we discovered what I call the Baskin-Robbins syndrome, with more flavors than we knew what to do with. Flexible premium, indeterminate, universal life, but none of these were guaranteed. So whole life is the first one that we'll talk about. And yes, whole life, if the full premium is paid, is 100% guaranteed. But once you begin mixing some term insurance with whole life, it affects the guarantees. And people do that to try to bring down the premiums to make the cost less expensive. But in doing so, they're in turn also negatively affecting the guarantees. Reduced dividends also affect guarantees. Trying to get this to move forward. There we go. Okay. Term insurance. Term insurance is wonderful for short-term needs. Not much to be said about that. There are no accumulations, and it's used for short-term needs such as family income, a buy-sell agreement, mortgage loans, a college fund. It's taking a long time for the slides to advance. I apologize. Okay. Variable insurance, neither the death benefit nor the duration of the contract, nor the premiums, nor the cash values, none of those are guaranteed. Variable life is good for overfunding and for tax-deferred growth. But when we have more risk-adverse clients taking advantage of this, if they're aggressive in their assumptions and those assumptions fall short, the contract will expire even sooner than before. It's just taking a while for the slides to advance. They eventually happen. Okay, with universal insurance, it's like term insurance, but it's longer and without the guarantees. Policy performance is based, as we'll find out, on the trustees' and advisors' actions and inactions. But currently, as we're aware of, those universal policies are non-guaranteed, and the duration of coverage is not guaranteed. But we wind up getting the most coverage for the least amount of money as opposed to a whole life contract. Okay, just some short facts about universal insurance because I know that Randy covered this. As a matter of fact, I'm going to look at the fact that 60% of private owners believe that their life insurance premiums are set in stone. In other words, that there's nothing else that they have to do. And 45%, as Randy mentioned earlier, are currently of that non-guaranteed nature. 70% of the amateur trustees, according to a recent Harris poll, 70% of the amateur trustees haven't reviewed their policies in 12 years. That's a long time for no action, and it's that inaction that has caused part of this problem. Interest rates affect the changes. When interest rates go up, the length of coverage can increase, the premiums can be reduced, and the dividends can be increased. But as is currently the case, when interest rates have gone down, the exact opposite happens as well. Let me just try to go through this with a case study. Back in 1987, a client was looking to purchase $1 million of coverage, and the agent would be the first one to ask, how long would you like that coverage to last? They agree to age 95, and they agree on an interest rate, and they assume a 9% interest rate. So they calculate that $1 million to age 95 would cost that client $14,000. The next step, because this was back in the 87 when the exemption was just shy of $600,000, let alone the $5.5 million that it is today, most large policies went into a trust. So the question became, who should be the owner of the trustee? Who should be the owner of the policy? And unfortunately, sometimes the eldest son or daughter was selected. However, there was no mention of the guarantee not being in effect and the changing of the coverage period, nor changing of interest rates and that it required active management, let alone the fact that the trustee had absolutely no qualifications nor the specialized knowledge to be able to handle it. So fast forward 30 years later, that 8 to 9% interest rate was not achieved. In fact, we achieved virtually half of that. And today, at the current $14,000 premium, that $14,000 will keep that policy in effect until 2017, until client's age 89. The premium needed today to keep that policy, that $1 million policy in effect until age 95, would be $26,000. The current premium, $14,000, will only provide $450,000 of coverage to age 95. This is the result of a buy and hold rather than a buy and manage situation. Universal life insurance is a good, flexible product, but does not come with auto self-management. It must be managed, it must be reviewed, it must be monitored, just like any other asset class. How long a policy lasts will basically depend on several things, and one most important is the action or the inaction of the advisor. And let's take a look at each one of those. The attorney might do a great job of collecting all the relevant data, reviewing the client intentions, and discussing the trustee, discussing the beneficiaries, and discussing the crummy provisions of the policy. But the attorney is usually not involved in providing guidance to the amateur trustee, nor to the owner, nor to discussing the need to monitor or review the policy's performance. Actively managing or adjusting the grantor's life insurance is, as we found out from the survey, not in the cards. The CPA may confirm whether or not the life insurance is required, may confirm the fact that there is adequate cash flow available to pay for the premiums, and here may or may not be involved in preparing the trust of the gift tax returns. But again, is usually not involved in pointing out the problem, nor the problem of the early expiration, does not touch on the performance evaluations, nor the annual monitoring, and certainly does not provide for adequacy of premium payments, because if he or she did, we wouldn't have the lapsing policy crisis that we do right now. The amateur trustee, great honor, usually the eldest son or daughter, is asked to sign as the owner or the trustee of the policy, but they're usually unaware of the assumed fiduciary liability. They're unaware of the performance risk that they've assumed, and they're unaware that they should actively be managing that policy. But they don't have the skills to monitor, to review, or adjust the policy, nor adjust the premiums. And they can't avoid the fiduciary liability, as we find out with Rafford versus Meyer, a Nebraska case, which I know Robert will be speaking about in a little bit, because the trustee has a non-waivable duty to the beneficiaries and can't get out of it. Suggestions such as hold harmless simply are not working. The traditional agent's role. Well, why doesn't the agent or the broker properly service? Well, quite simply, because there's no financial incentive to service an existing policyholder. The majority of the commissions that an agent or broker earns are earned up front, and they only receive perhaps a 5% service fee for ongoing service. There are many people who unfortunately leave the business or retire from the business. They're embarrassed for perhaps not providing sufficient services, and they treat an orphan policy as an opportunity to sell someone rather than as an opportunity to service someone. And as we find out from UBS Financial Services versus Thompson, the agent only has the duty to market and deliver policies, not to manage the policy. That's the trustee's job. I'd like to pause here for a moment and leave you with a quote from the Wall Street Journal that also acted as an endorsement on the back book cover of our book. I'm not going to read this, but I think if you just take a moment, you'll understand the gist of what a senior editor for the Wall Street Journal felt. People are not doing what they should be doing. People are unaware. People don't want to talk about this. People don't trust the individual that's providing the information. And what we're talking about, what she's talking about, are your clients' children and your next generation of clients. With that, I'm going to turn it back over to you, Jennifer.
Thank you so much, Henry. Okay, let's turn it now over to Robert for selected trust anatomy.
Okay, and good afternoon. Let me see. Here we go. What I'm going to talk about is a little bit of the drafting and some of the provisions within the trust in my first section. My second section, a little bit about trustee obligations and duties. So first I want to back up and speak a little bit about insurance trusts. I'm not sure if everyone on this call understands some of the operations and some of the techniques. So the first step in the lawyer's role is look at drafting. And I've given 5 general steps here. Confirm the insured, owner, and beneficiary. And we'll dig into each of these in a little bit of detail. Avoiding incidents of ownership within the drafting, items that may evolve back from an estate point of view. Looking at gift issues, we call them the crummy powers, the rights of withdrawal. Looking at the technical tax status of these trusts, grantor trusts, and generation skipping. All are important. And I would say this, when an attorney is looking at preparing, reviewing, maybe decanting a life insurance trust, seeing how it's working, the first step is getting all the information, understanding the family, understanding health issues, understanding ability of future management, trustees, what are the beneficiary status in life, and how will this trust affect them. Is it in an already existing insurance policy? Does the settlor of this policy already own this insurance, and or is it a new policy or maybe a blend and a mixture of all of that? Are we looking at marital deduction issues from a tax point of view? And that's very important. And I seem to be experiencing Henry's, nope, there we go. Okay. I think I clicked twice, so I'm going to go back one. What is very important, this triangle should be in your work papers. Every time you are looking at understanding and reviewing an insurance policy, whether it is in a trust or not. And it is the triangle. The insured, I put the insured on the top of the triangle. I've seen it done differently, but I like the insured up there because that's the person who's eventually going to die and kind of tumble down, right? If everything kind of goes as planned. We then have the owner and the beneficiary. Now, you should always be putting designations in these spots, and I know it sounds simple, but I will tell you that every time I review one of these designations, about 25% of the time the clients are shocked to see that there was a piece of this puzzle missing. So as you're listening to Randy, as you're listening to Henry, I'm backing up another step of where I see a lot of malpractice, and that is in the initial setup and paperwork within the policy itself. So let me give you an example. Insured is H. Owner can be child number 1 or 2. I've seen that happen. It can be wife number 2 as the owner. Beneficiary may be wife number 1. I've seen these situations. Maybe the beneficiary are all the children. But when you look at that, so let's take the simple example. I trust my son, number 1, to do the right thing. I make him the owner, and the beneficiary of this policy are all my children. I then create an income tax problem or a gift tax problem for my son, who is now being treated as having made a gift to his siblings. Very awkward. I have had the situation, the owner being wife number 2 and beneficiary still being wife number 1. Need I say any more? Obviously, those have to be reviewed, and you have to know, because you might be doing perfect paperwork that is perfectly wrong because what your client told you was not how the documentation existed. Careful drafting. Avoid the insured having rights and benefits within the trust that would create any of these rights or powers. The one I see that sneaks up on people is reversions. If someone were to die or predecease, then the policy control reverting back to the insured, I see that often, and it can create a tax problem. When you have incidents of ownership, the policy is back in the insured's estate. Now, let me take that as an opportunity to say and to ask the question, what is the purpose behind the life insurance trust to begin with? Was it a purpose to avoid estate inclusion? Is that purpose still germane and important to the family? Was it a power over control and designation of the policy and the proceeds? So you do need to look at this in the context of the estate and the settlor's intentions. And by the way, those should be documented at the very least in the attorney's work papers and memos to the file. Could be important later on. So what we create generally are these rights called withdrawal rights. I don't want to click. There we go. And the reason we generally have created these withdrawal rights are so that the policy will benefit from a gift exemption. We all know that we're allowed to give presently $14,000 as a gift to anyone we want in the whole world. So even Bill Gates, if he were to do that, would soon become and have a non-taxable estate. So the question becomes, If it is a gift in trust, that will not qualify because that is what we call a future gift, not a present gift. So this withdrawal right, I'm sure you've all heard the term crummies, is used to make the future gift a present gift. You must be very careful in drafting. If you give the surviving spouse too much power in terms of the withdrawal, you may be creating estate inclusion in that second spouse's estate. A safe way is to limit that spouse's withdrawal right to no more than $5,000. You can't create a naked withdrawal right. The person has to have some expectation within the insurance trust. So trust for spouse, then children. God forbid a child is now then gone, or maybe we did a generation skipping trust, then to children. We then have a right, and we can create these withdrawal powers for children, grandchildren, and spouse. I think I just clicked twice, and we may have a problem. I do point out in this slide there was a Turner case. Best practice, do the crummy notices. If the client hasn't, look at the Turner case. You may be able to argue that everyone knew of the annual premiums, knew of the policy provisions, and so notice was not required. To my recollection, Turner is the only case that has been so generous to people that have not followed the requirements. So you want to be careful. Time permitting, we can go back to these withdrawal right notices, and I'm not sure that I want to dwell on them now, but if we have time later, we can go back. It has to be a legally enforceable right. There was a recent case that involved a very broad interim clause within the trust. We see them being used much more often in our wills and trusts. And if it is a very broad interim clause, it may be impacting the withdrawal rights. And so you may want to be very, very careful on how you draft that withdrawal, the interim clause, and how it interreacts, because this chief counsel advice recently in 2012 said it made the withdrawal right an illusory right because somebody would not have their rights under the policy to have the withdrawal under the trust. So the beneficiary's participation in that proceeding would ruin their ability to have the withdrawal right, and they said no good. It will taint the whole thing. So the specific provisions for a grantor trust, very important. It is essential that life insurance trusts be structured for tax purposes as grantor trusts. So you need to have your specific provisions. That's a 2-hour lecture in and of itself. But they are going to protect you, the drafter, and the client from future policy transfers. You may need to decant. You may want to take that policy, move it into a new trust. The IRS has been very generous. There have been a lot of good private letter rulings saying if we're going from a grantor trust back to the grantor or to another grantor trust, we're in good shape. There's even one that refers as a grantor trust to the grantor trust, so it's very interesting. But it's a trap. Whenever you move life insurance, whenever you place life insurance in a trust, make sure that you do not trap the transfer for value trap, which makes the life insurance taxable. It will, and this is applicable to corporate transfers and individual transfers as well, where there's a transfer for value. Where your ILIT is a grantor trust, this trap is neutralized. Again, watch your incidence of ownership. The way we get that grantor trust is we use Rev Rule 2011-28, which was very permissive. You put a provision in allowing the settlor to exchange assets of equivalent value, and as long as you don't ruin the duty of impartiality, we'll be talking a lot later about trustee duties, you cannot use this as a subterfuge to shift benefits, but if you follow the language in the ruling, you will be protected. Again, it was mentioned, I think, Randy, that often these trusts go to a spouse, then they go to children for life, then grandchildren. Proper drafting for generation skipping is a lecture in and of itself, I promise you, but I did want you to put it on your checklist. You want to be able to use separate shares. I give you the reg in the outline, Treasury Reg 26.2654-1, talks about this separate share where you use this. It's treated as a separate trust, and it allows you to carve out your allocation of your premium between the children and the grandchildren. It's very effective. We use this all the time. So if you're not using it, let me give you two instances where you should be consulting this in your drafting. One is where you may be setting up this trust in a family where there was a predeceased child that had issue. So you're going to be creating a share for those grandchildren of the predeceased child. If you use that as a separate share, you can do very, very flexible and much better and efficient allocations of the generation skipping exemption. Also, we've done it in situations where there's, say, 4 children. One of them is very wealthy, says, "Mom, I'd rather bypass my rights here. Why don't you go right to my kids?" And using the separate share, extremely flexible. I'll part with the newest and the most important, I think, in drafting is draft, because insurance trusts are designed. Part of what we've heard in the opening is these are slippery creatures, partially because of the assets or asset, single class, a lot more on that later, but also because they are designed to last for a long period of time. Economics change. We saw the huge decline in interest rates. But let me tell you this. Families change. Family finances change. The need to change and modify, possibly through decanting, possibly through use of an independent trustee in your drafting, is extremely important to address these family and individual changes.
Before the problems advisors and trustees face, can you spend some time on solutions with us?
Yeah, sure. So let me just summarize for a moment. Okay, so let me just summarize for a moment. As we say, why is the evaluation needed? Well, very simply because very few owners and trustees know that there's a problem and few advisors are around to be able to provide them with the guidance that they need, primarily increasing the premium or making some sort of adjustments. So with your question, let me focus on some of those solutions. Okay. What I consider the UPIA and the IPS and the AFS, they're only alphabet soup until you put some meaning to them. The investment policy statement very succinctly tells everyone, it's a roadmap, it tells everyone what to do. It tells every owner and every trustee that they should obtain the grantor's guidance in terms of what's the purpose for the policy, what's the intent, what needs to be done for the individual specific beneficiaries, what are some of the current risk tolerances that the individuals have, and what happens if the policy does lapse. What does the grantor actually want to have happen? The next slide talks about the UPIA, and very simply and very basically it just says let's treat life insurance just like every other policy class, just like every other asset class rather, and that means that it's subject to review and subject to monitoring. The adequate funding statement to me is one of the most important aspects, and this makes certain that the policy is sufficiently funded so that the policy lasts at least until life expectancy or beyond that, depending on what the individual grantor or the individual trustee wants to have happen. Now, there are several remediation options, getting back to your question. One is, of course, to be able to reduce the face amount. Secondly is to be able to pay a higher premium. If the insured is healthy enough, we may be able to obtain a new guaranteed contract if the individual qualifies. The fourth option is something called the life settlement. An individual can sell their life insurance policy just like they can a house or a home. Unfortunately, as Randy mentioned earlier, $112 billion of life insurance lapsed. And what that means is that there's no value that the individual is receiving. There's just nothing that the individual gets for all of those years, and it's absolutely the worst option for a client. A client can convert to an income stream. A client can decide to use part of the cash value to pay for a long-term care insurance contract. If the policy happens to be a whole life policy and there are loans taken against it and the loans become non-manageable, then we have to in some manner be able to keep that contract in force to avoid a taxable gain. Worst situation is when an individual doesn't have the money to pay a tax bill, and the objectives, as far as I'm concerned, are basically just to lengthen the guaranteed duration of coverage and to realign a client's or policyholder's current holdings with their corrected objectives. And the best way that I could show that is just taking a recent example of a client who had a $1 million second to die policy because all he wanted was to leave the maximum inheritance to his kids. There was no intention of ever using the cash value, so he bought a second to die policy. But he bought a policy that's a whole life, directly opposed to his wishes of not needing or wanting to use any of the cash value. So in looking at his current objectives and looking at what he actually owned, I was able to realign his current policy with his current objectives. And what I did is I took the cash value from that existing whole life policy and did what's known as a 1035 tax-free exchange. But when I used the right product, which was a guaranteed universal product, I was able to actually increase his death benefit from $1 million to $2 million using the same $16,000 premium.
That's a great solution, Henry. Thank you so much.
With that, I'm going to turn it back over to you, Jennifer. Thank you.
All right. So we have about 15 minutes left before Q&A time. So, Robert, let's get back to you to discuss fiduciary responsibilities.
Okay. This is a great area, and I think it's going to maybe put a lot of what we've heard into a little bit of perspective, perhaps. And that is, well, here's what I see, right? I see that the client comes in to me and the client wants a life insurance trust, and the rationale for that historically has been because they want the insurance to be outside of their estate. They have worked with an insurance person, and what have they done? They've picked the cheapest policy, probably, that they could possibly find, and maybe they've done a various combinations of a lot of term in the mixture, and there's a whole litany of risks that Randy has gone over vis-a-vis the ability of this particular insurance to survive. and maybe need a little more nurturing or things of that nature. So product selection and suitability really starts when I look at fiduciary responsibility. But we may be, as attorneys, drafting this trust for the settlor. Who is our client? Maybe 3 or 4 minutes of ethical thought needs to kind of go into any of these engagements because, well, the person that's in charge of this trust is the trustee. We're probably drafting the trust for the settlor. And so, a minute or two thinking about that is probably very, very crucial. So cheaper is better, as we all know, but Randy, of course, is showing us why that may not work. The other is areas of the prudent investor standard. Well, diversification, delegation, the fiduciary duty in that. While we look at some of that, the prudent investor standard requires diversification. Am I diversified? Well, obviously not. This insurance trust is holding a single asset class, so to speak, of an insurance policy with a lot of legalese in the middle of it. There may be a lot of hair trigger issues where I've got some guarantees, but if a premium is late, those guarantees disappear and the product design changes. Is the trustee now liable? And a little bit more on that later. Obviously, delegation, indemnification, very important. Risk mitigation, what are the purposes? Well, let's say the purposes were for estate taxes, and now we find ourselves, because of portability and the high exemptions, not in an estate tax consequence. Should we look at this? Should we review it? What is our policy statement? What was the intent? Where is that documented within the policy? Well, we see this often. What do I do? The client may come in and go, hey, I got an unnecessary policy. I don't want to keep doing this the way I'm doing it. Well, we can let it lapse. There could be some income tax consequences to that lapse, by the way. And these are grantor trusts, so they're going to be taxed to the settlor most likely. We need to get a very experienced person to help us get that data that we need, number one. Number two, is the trustee liable for that lapse? Wow. Maybe I can use, if the trust is drafted very flexibly, an independent trustee to give that policy back to the insured or maybe to the insured spouse. Probably can't get it back to the insured because initially that was probably not allowed in the drafting, but it might be able to get that to the spouse. I got to watch my 101 transfer for value issues. Does that trigger it? Spouse might be able to then gift it back to the insured. Watch my step transaction. You see there's a whole lot there. But the insured could then maybe donate it to a charity. Maybe that's an interesting final resting place for an unnecessary policy. The insured can then make gifts tax deductible to the 501c3 that will then keep paying those premiums. Kind of interesting. Again, we have a lot of fiduciary responsibilities within that. So very, very important. So we have our duties: loyalty, care and prudence. We've been hearing about that all afternoon. No self-dealing. The duty of diversification is paramount. So I challenge you to read your life insurance trusts and see where you have written about these duties vis-a-vis the life insurance. Your life insurance trust says, my trustee is authorized to invest in and buy a life insurance policy on the life of settler and or settler spouse. And maybe there's some language in there that there's no requirement to pay the premiums. We'll talk about that in a minute and see where that goes. But in New York, we have our EPTL standard here, but this is the Standard Uniform Prudent Investor Act as we have it in New York. It's a standard of duty and conduct that requires diligence, review, and delegation. It requires diversification. And where do we stand now with this life insurance policy, and how have each of us in our requisite states drafted to override what these requirements may be, because we're putting the trustee obviously in a very big pickle here because we're probably not really diversified. We haven't really looked at our delegation closely, right? The insurance person came in with the set law, and where have we reviewed this policy? Where have we reviewed the longevity? Where have we seen the Monte Carlo analysis? And is our trustee now going to be held to to some liability here if this policy doesn't achieve its intended results? Can I draft for exculpation? Generally, almost every state requires some skin in the game. So at the very least, you're going to need ordinary due diligence, and that's usually a question of fact for a jury, and so have some of the recent cases that I'll talk about. So the key here is, yeah, we can delegate, but have we really delegated? I really don't think so. In most instances, we've neglected, or the trustee has neglected, not delegated, because this was a set and forget kind of a thing. You know, we thought because the policy had a name of a big insurance company on it, nothing could possibly go wrong. And as we've seen, these are very complicated financial documents, and a lot can go wrong, especially where the client was interested in the cheapest possible annual price, and maybe there were areas where some of the protections have been overseen. So we've got periodic review, which is required. So what have we been seeing? We've been seeing exculpation clauses generally not being upheld and allowed, and we've been seeing these accommodation trustees who are usually close friends, colleagues, or the number one son or daughter in pretty hot soup. So let me give you a run-of-the-mill kind of a case, but we can change the fact pattern a little and play around.
Robert,
Dr.
if I can just Robert,
sure.
if I can just interrupt for 1 second. We only have about 5 minutes left, so if you could maybe
Sure.
wrap your part up, and we'll turn back to Randy.
Perfect. Let me do that. So what we've seen in the cases, for the most part, are policies that lapsed because of premiums being unpaid or policies being neglected. Or we've seen policies being hurt by financial feeding, good premium payments that weren't made and reduced the value of the contract. And the courts have said to the trustees, you're either liable or this is a question of fact for the jury. And there have been a lot of strange facts in some of the cases, which I will not go through. But the other is that the boilerplate language of indemnification and limitation of exculpation of liability has not been affected, especially and not been effective, especially in these cases, Raffert and UBS, where policies actually had lapsed or been seriously undermined by inattention. And the takeaway is the fiscal duties on the trustees have been upheld and are being upheld in the various cases throughout multiple jurisdictions.
So Robert mentioned that big name insurance companies. Well, I just want to say something. Big name insurance companies, small name insurance companies don't matter. Let's just take a look at what the insurance company's posturing. We've looked at the trustees, we've looked at the attorneys, the advisors, we've looked at the agents. The insurance company's prime responsibility is to market, not manage. The insurer's duty is to just basically provide a policy and an annual statement. And that annual statement encourages what I consider just a buy and hold. And the insurance companies have created a perfect storm. In addition to the low interest rates and neglect, the companies currently are increasing the COIs that Randy made reference to before. The COIs stand for cost of insurance. This is the first time ever that insurance companies have exercised this option. What they've done, as far as I'm concerned, is they're further exacerbating an already deteriorating situation. And why are they doing that? Because it's in their best interest, because insurers like when policies expire. Unlike a current situation where we have the spirit of the Department of Labor ruling, do what's best for the customer, the insurance industry is not obligated to do what's in the best interest of their customer. Their objective is to do what's in the best interest of their stockholders. So this is a 6-page report issued by typically any insurance company. And all the way at the bottom, if you take a look, it says, important notice. Well, that important notice is on page 3 in small type. If this was really an important statement, it should be in bold letters, in red, bold, big black letters at the top of this situation. And what that says is that current situations may dictate the fact that your insurance policy may expire prematurely based on interest rates. The insurance industry really is not interested in having you be aware. So it's really up to the individual trustee and their advisors to inform their clients to not treat their insurance policy and not just let it sit in the bottom left-hand drawer. It will not just take care of itself. It's in your best interest and your beneficiary's next interest. And for the advisors, it's in your best interest to not go to the insurance to that client after the fact. It's far better to go to that client before the fact.
Looking at this from the role of the attorney, which is something that we spoke about earlier, I think that the attorney has to look at a few things. And the first is the assemblage of the parties before the attorney, what their expectation is, and who that client is. And I don't think that the attorney is necessarily going to ever become an expert in all the various insurance products and how they operate positively and negatively in different economic times. But I think it is the role of the attorney to first and foremost create a trust which has a proper foundation and that can service the various needs and that allows the fiduciary and informs the fiduciary that the annual updates can be paid for by the trust, that the fiduciary should be encouraged to obtain financial review of the policy, and that that review can be paid for from the trust assets. So number one, you're acknowledging and informing the trustee of this, and that the trustee feels very, very safe that those kinds of reviews are appropriate within the settlor's intent and also within the trustee's purview to accomplish through the checkbook of the trust. If there are shortfalls, the documentation and the powers of the trustee need to be set out in the instrument very broadly and very clearly, that the trustee should have the power to modify the insurance, perhaps to lower the face value, as I think Randy was saying, to engage potentially in 1031 exchanges, 1035 in the insurance exchanges, and to do what is necessary. And even though the exculpatory language will not be followed if the trustee is neglectful, having broad exculpatory language where the trustee has exercised due diligence and exercised those duties, I think will be found to protect the trustee. So clearly I'm not saying not to draft it, but I'm saying to draft them with the full protection available under each of our state laws, but to also inform the trustee, maybe through an annual letter. You know, we do those crummy withdrawal letters every year. We should also be sending a review letter out along with that, that indicates and tells the trustees that this is an asset that needs to be reviewed, as the portfolio analysis would need to be reviewed if they were common stocks.
I'd just like to conclude for a quick second just to say that in your handout packet is a discount flyer for the life insurance policy crisis, and you could just take advantage of that by completing it and sending it in. Also, if anyone is interested in the information and would like to do a review of the book, the ABA has agreed to send out a book in exchange for a 500, 700-word review, which can appear on the ABA website. Thank you.
Great. Thank you so much, panelists. We have a few minutes left for some questions. Henry, this one seems directed for you. One of the most significant issues facing the aging population is long-term care needs, as most seniors are inadequately insured. Do you have any recommendations whether an insured should address these concerns with either existing life insurance policies or new policies using a 1035 exchange?
Sure. Thank you. Yes, I agree. Long-term care is a very significant and important issue, and the pricing on long-term care insurance has gone through the roof. So many people, unfortunately, are shying away from the individual traditional standalone policies. Fortunately, in 2006, the insurance industry participated in the 2006 Pension Protection Act, which became effective January 1st, 2010. What that did is it opened the door for insurance companies to begin allowing what they call combo or hybrid or linked insurance policies. And what they do is they allow individuals to withdraw, based on certain qualifications, to withdraw money from the death benefit of an insurance policy to be used to pay for an individual's long-term care insurance or long-term care needs on a tax-free basis. Very significant, very important item, and I think that it behooves individuals to take a look at these new policies that became available after 2012. It's a very important issue, and this is one way to cover it.
Great. We have some other questions in the queue, but do we have any callers on the line, Diana?
At this time, Jen, we do not.
Okay, great. I'm going to proceed on with what we have here. Robert, this one's for you. 13 or more states have adopted statutes holding trustees harmless for failing insurance contracts. Is this a trend that minimizes the risk for a trustee, or are there risks beyond what the statutory exemptions provide?
I think that the trustees are still going to be liable for the breaches of their customary duties, and I would take a very close look at the breadth of those statutes, because I think, number one, it's going to become very state specific, but I personally do not see that the traditional role of prudence and diligence is going to be completely upended. I think what we are going to see is a situation where exculpation will be effective if, number one, if it's in the document and indicates the settlor's intent, where they acknowledge that it is intended to hold life insurance and not intended to be a diversified trust. I think that language is missing from almost every trust I've ever read. Number two, where I think that most of the states will require that the trustee use ordinary care and prudence. So for example, one of the cases, the trustee used a false address. Nobody knows why. And the premium notices went to a fake address, and the premiums didn't get paid. I cannot see any state using an exculpatory clause to exonerate a trustee in a situation like that. In addition, I think that if there were a complete inattention to the annual financial disclosures that accompanied this product, so a normally prudent business person would have seen that the policy was in trouble, I don't see exculpation being effective in most states. I don't know how Henry feels about that. Maybe Henry can speak for a minute on what they see there, if they see something different.
Yeah, and I obviously also agree. It's a function of doing what's right for the client, and you can't just expect the client to know what to do. He or she needs some guidance, and I think that's what this entire presentation was about. The advisor has that opportunity, has that, as far as I'm concerned, that responsibility. And the answer is not in drafting. The answer is in communication and having the client become aware of what he or she needs to do to be able to pass that policy on to the next generation.
Okay. I think we have time for one more. I'm not sure who wants this one. Is there any litigation happening currently regarding the lapsing policy crisis? And if yes, what are the issues? Can someone briefly take that?
There's a case called Ionaro versus Bachman, which rather than explaining, you might just want to jot down and just take a look at. And secondly, there are many class actions taken against insurance companies. People are very upset that various insurance companies are beginning to exercise the ability of increasing the cost of insurance. And they're doing this not across the board, but they're doing it in very specific situations, and they're discriminating. So that's another situation that brings to light the litigation on a class action basis.
Mm-hmm. Yeah, and I believe Raffert is still working its way through the courts on appeal. Gadar v. Orkin, which was is a district court case, D.C., I believe, and that deals with a lapse of a policy and a lack of ordinary diligence, which is a question for the trier of fact. And ordinary diligence, I don't particularly see a trustee ever being able to shed that. So those are two cases I'm aware of. I believe they're both still active.
Great. Thank you so much, panelists. That's all the time we have. But before we leave, I want to make sure that all the attendees who want CLE credit stay connected for instructions at the end. I just want to thank our faculty again, Robert Barnett, E. Randolph Whitelaw, Henry Montag. Thank you so much for sharing all of your experiences with us. On behalf of the ABA, I'm Jennifer Kona, and I want to thank you all for joining us.
Thank you.
Before leaving, please just wait for the evaluation to come up on your screen. And I'll turn it over now to Diana for some more information. Thank you, everybody.
Thank you, Jennifer. Ladies and gentlemen, you may post additional questions or comments on the web board for this program. On behalf of the American Bar Association, the ABA Center for Professional Development, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.